Legal 114 Family Law. This is your week one podcast for section one of the course. For this podcast, I'm going to speak to a degree about things that cover both the 114 Family Law course and the 115 Wills, Trust, and Estates course, because for family law, I am going to speak to a large degree about ethics, and I'll incorporate what those expectations are for wills, trusts, and estates as well. And ethics, when we talk about ethics and professional responsibility, we know that what we're really concerned with is you not doing things you shouldn't do, and the lawyer doing things they're supposed to, and everybody doing things according to the law, the rules of professional responsibility, and the ability for all of us to serve the public, our clients, to make a living, and to do things to the best of our ability. At this point in either course, I expect that you've read the syllabus, and if you haven't, you should, and you should review it and go back to it regularly if needed. It's right there in Canvas. For either course, the sources of law are primarily statutory, and links will be provided on Canvas for the applicable statutes in each course. And then the other body of law that becomes most important would be case law, because case law to a large degree helps us understand what it is that we are trying to get from the statutes, how the statutes apply to any given factual situation. As you have in other courses, you have one of the best secondary sources available to you, and we will lean heavily on that secondary source, the Ickel volumes that relate to the subjects we will cover in those courses. And it's up to you to go and to find much of what you need to find in those volumes, because you need to be practicing using secondary sources. In all likelihood, you'll probably never again in your life have as much access to a resource like Ickel, just because it's so cost prohibitive for a sole practitioner or even a law firm. Lawyers in our region tend to access something like Ickel based on what they practice in, the area of practice, and only for those resources. You've either completed legal research prior to taking this class, or you are halfway through it at the point that you're starting this class, or you're maybe in it, depending on what term we're in. For this spring of 2025, anybody enrolled in this class should have had legal research or been halfway through it. But if you've had legal research or you're halfway through it, you know that I use Google, and I especially like bar journals and law journals as other secondary sources that will lead me to primary law, the statutes and cases that we will use in family law and wills, trusts, and estates on most days. But again, you have the best available secondary source, Ickel. Why is it a secondary source? I shouldn't need to answer that question for you. So if you don't know that answer to that question, stop, go back, review your legal research notes, and figure that out. Primary sources, statutes and cases. Secondary sources, Ickel, and the other things I've mentioned. You have to I'll have to apologize for my coworker. I don't know what he's barking at, but I'm not going to stop. There's certain skills that are expected of legal professionals, and when I say legal professionals, these go to the lawyers or legal assistants or paralegals working in these areas of the law. Of course, research and investigation skills, technology skills, which you have to update all the time, and these areas of practice, math skills, and in most areas of the practice of law, math skills, basic math, add, subtract, multiply, divide, the type of math that you should be familiar with from your daily lives. That's the kind of math that you do in these classes. You also need to have good organizational and multitasking skills. Detail-oriented people do better in these areas of practice, but in all areas of the law. I mean, if you're not detail-oriented or you don't practice being detail-oriented, you're going to get lost and create mistakes. I talk a lot about focus, about effort, about attitude. Focus to me becomes a topic that I find myself preaching on more and more the more technologically dependent and lost we become. The ability to take a deep breath, to slow yourself down, to use the most important computer you will ever own, your brain, and then putting the effort into whatever it is you're supposed to be doing, whatever time and sweat and equity you have to put into that. Not relying on anything else but your brain. Owning whatever the task may be with an attitude that you are going to own it. If you want to be successful in the legal professions, you have to do these things. And then the final one I'll mention right now, and there's probably others I'll mention over the course of the semester, team skills. You have to be able to work with other people. You have to be open to other people reviewing and critiquing your work. And you have to be willing to also review and critique their work. You have to do things together, regardless of who is doing what on a particular case or project, and support one another as a team. And that's why we do so many of the things we do in these courses, especially when you may notice that I sort of step out of the way on the discussions, and sometimes the discussions become, very helpful. Sometimes people check out clearly on the discussions and don't give as much input, but the people who consistently practice that level of ownership in what they present, and then the teamwork and the willingness to share and sometimes be objectively critical, not less than objectively critical, constructively critical, I should say, end up having the most successful careers. Now, I know you've read the syllabus, or you stopped and went back to read the syllabus, but you should be aware that the scope of family law, primarily it's these topics: marriage and premarital issues, divorce, child custody and child support, marital property, the whole ball of wax, maintenance, marital residence, bank accounts, vehicles, the whole ball of wax. Paternity, who is the father? We typically are able to track the mother. Not always, and we'll get into that. Adoption, and sometimes abuse and neglect when it comes to children. We'll also touch on domestic violence, domestic abuse, and the resources there. For wills, trusts, and estates, for those of you in that course, we essentially assist with planning for the use of property while someone's alive, the distribution of property after they pass away, and how to avoid as many issues or losses regarding that property as possible all the way through from the time they come to see us, the time that they remain alive, their use and enjoyment, benefit of that property, and then how it's distributed after they pass away. So it involves estate planning. It involves inventorying and analyzing the property. One of the topics that we'll talk about for week 1 in that course, property, real and personal. The ability to work and get information from other professionals, from investment and insurance professionals, bankers, etc. The ability to understand what those documents and the information means. It involves drafting wills, powers of attorney, living wills, trust documents. And then at the end of life, it sometimes involves estate administration, probate, or intestate succession, all things that you will learn about. Now, for either of these topics, either of these courses, the Illinois Department of Public Health is responsible for keeping the records in our lives. Birth records, death records, marriage records, divorce records, adoption records, all the records related to human life and interactions. The Illinois Department of Public Health. They also keep, for the purposes of all those things, statistics. Although, depending on their staffing and their abilities, those statistics are typically a little behind. And so, for instance, divorce rates and marriage rates. I used to say that 50% of first and second marriages, ballpark 50%, ended in divorce. And that may still be true, but we don't know that because I don't think those stats are up to date. But you can always go to their website and take a look at what they keep and any information they have, the Illinois Department of Public Health. Family laws of litigation, for those of you who had civil litigation in the fall, the Code of Civil Procedure and the same Supreme Court rules apply to discovery, etc. And you've drafted a complaint in that course, so you won't have any problem drafting a divorce petition, the complaint of a divorce case. Just a different name, same functions, same use. In wills, trusts, and estates, it can be litigation, but it's largely, and if you're lucky, it is much more transactional. It's not as much litigation, although you do have to go to court to report to the judge and move the estate through the courts when somebody dies, and probate or no will or ability to pass the property otherwise is required. So let's talk about the Illinois ethics and professional responsibility expected of legal professionals in any area of the law, but I'll make some comments along the way about things related specifically to these areas of the law, the spring courses 114 and 115. The preamble of the Code of Professional Responsibility provides in part that a lawyer is a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. It goes on to explain a lawyer's responsibility to provide a client with an understanding of their legal rights and obligations and to explain the practical implications of those rights and obligations. To zealously assert the client's position under rules of an adversary system. To negotiate the result that is advantageous to the client but consistent with the requirements of being honest when dealing with others. I can tell you that that doesn't always occur. As legal professionals, we're expected to be competent, prompt, and diligent. And we'll talk about rules that flesh that out. We're supposed to maintain communication with a client. We'll talk about that. Keep confidences, and we'll talk about that. We're supposed to use laws, procedures for legitimate purposes and not to harass or intimidate others. Now, in family law cases, divorce in particular, and probably more so than you'd find in wills, trusts, and estates or in probate cases, we see laws and procedures sometimes used to harass or intimidate or to delay or whatever. And I've lived through that. It happens. There are lawyers who have a license who do this to other lawyers and other parties, people, to people's lives. It's unfortunate, but they're not supposed to, and that's the point. Ultimately, eventually, they get in trouble. They lose their license at some point because they just can't stop. We're supposed to demonstrate respect for the legal system and all those who serve it, including judges, other lawyers, and public officials. Doesn't always happen. Challenge official actions when necessary while also upholding the legal process. We have a duty to seek the improvement of the law, access to the legal system, administration of justice, and the quality of service rendered by the legal profession. A lot of times we do that by, or we should do that by, working with people to update the law. The current statute is going to be 9 years old, coming up on a decade. And back when it was being proposed and moving its way through the legislature towards the governor's desk, I reviewed various parts of the bills and gave my input for local legislators from both parties. Because especially with family law, but also with the laws of probate, we're talking about areas of the law that definitely impact both the parties and then third parties. And a lot of times interfere with the peace and prosperity of innocent third parties like children or just the public, neighbors, whatever. It has an opportunity to be very emotional. And so the idea of the statute 10 years ago or more, 9 years ago was passed or became law, but went into effect, but it was passed about 10 years ago. And the idea was to make things more efficient, more streamlined. I'll talk at various points along the way, but my opinion is that did not happen, largely because lawyers and sometimes judges approach things in the same way, and the cases get punted down the road. And some lawyers, I think the majority of lawyers, try to move cases as they're supposed to, but some of the things, in particular in family law, allow for delay, and delay in family law cases can mean just disruption, chaos for the people, your client, the other client, and anybody involved with those people. And sometimes lawyers can be callous about those things. We're supposed to use our training, experience, and skills to provide services in the public interest, so pro bono, without expectation of compensation. Some lawyers do this to a large degree. Some lawyers don't do it at all, and hopefully many fall in between. There's a time in my career when I did a lot of it, and I was supported by a staff, and I try to keep my hand in it. I mean, pro bono is just, and occasionally one of you or more may have called me with a legal question. That's pro bono. And I've probably given you either a resource or a referral to a lawyer who can help you. I don't do any practice. I participate in the Prairie State Legal Services pro bono clinics occasionally where it's just a one-time advice to a particular person that Prairie State asked me to talk to. But I don't do any sort of practice of the law anymore because I don't have the staff. I don't have the ability to handle it properly. And since COVID, really, I just haven't, I've had a workload that's been way beyond what it was prior to. And so I've given up everything that I've ever done. I still participate with Prairie State's clinics, legal clinics, because it's an hour commitment every so often. And I still help people from around the college, faculty, staff, students, where I can. Again, not being their lawyer, being a resource as I can. We're supposed to strive to attain the highest level of skill to improve the law and the legal profession and exemplify the legal profession's ideals of public service. You hear me say this all the time, but whether you're taking a fee or not, whether you're working for the state's attorney or the public defender, or you're working in the biggest private law firm in town billing out a lot of money to a client, you are serving the public. It's a public service. We're supposed to meet our obligations zealously and protect and pursue a client's legitimate interests within the bounds of the law while maintaining a professional, courteous, and civil attitude towards all persons involved in the legal system. And we're supposed to observe and abide by the rules of professional conduct and aid in making sure lawyers do as well, other lawyers do as well. Make sure they meet their responsibilities, their compromises without compromise, that they don't do anything to hinder our profession, the public interest it's supposed to serve. In other words, we have a duty to police ourselves and our profession. That's a theme that I carry to my law enforcement students as well. In fact, I have a class that I'm putting together that hopefully be out there by the 1st of June. It's coming up on 5 years since George Floyd, and there was always, and there will be hereafter, a duty to intervene for police officers. That's a whole different topic, but we have a duty in the law to police ourselves, to make sure that lawyers who aren't abiding by the law and the rules of the court and all of the things do so. And I've experienced that. I experienced it recently. It still happens. And we have a duty to let the court know. And then sometimes, if it rises to the level, let the Attorney Registration and Disciplinary Commission know. So I want to break down just some of the rules, not all of the rules, but the ones that I want you to focus on. And of course, you're supposed to be going and reading all of the rules. And where applicable, we get into other rules along the way. But Rule 1.1 talks about competence, and it expects that you have an ongoing duty to provide competent representation to every client. The words that were typically associated with this rule were the legal knowledge, skill, thoroughness, and preparation necessary for the representation. And the way I always looked at that was that you can gather the knowledge and skill. You're gathering knowledge and skill by taking family law or wills, trusts, and estates. And once you have that knowledge and skill, you can be thorough. But thoroughness and preparation are really a choice. That's that effort and attitude thing. If we don't know what we're doing, and even if we're trying to gather the legal knowledge, skill, thoroughness, and preparation, we have an absolute obligation to secure the assistance of a lawyer who is competent in the area of law or practice in which we aren't. A few weeks ago, one of my former law partners was honored as a pillar of the Peoria County Bar Association, and so Dean Weghorst and I went to the ceremony, and in a phone call few days before, Max and I were reminiscing. Max Prusak was my former partner and one of my biggest mentors in the law, and we were reminiscing about the week after I was sworn in by the Supreme Court to practice law. And essentially, here's what I found. No, Siri's talking to me. You ever have one of those days? Essentially, the week I was sworn in as a green young lawyer, but I was a lawyer. I was able to go practice law, right? Max sends me over to a hearing with Judge Mim on a case regarding the federal statute known as the Employee Retirement Income Security Act. This volumes of statute about essentially anything related to income, especially income that was covered by some sort of contract. And in this case, we represented a large health insurance insurer. In this big case, the employer was getting sued, the shareholders were getting sued, and everybody else, including this health insurance company, was getting sued for cutting off benefits to a large group of plaintiffs. Max had no clue what that statute was about. I didn't either. It wasn't covered in any class, or maybe it was, that I had in law school. It wasn't covered in a bar review. Okay. I hadn't done much on the civil side of the courthouse, and now I'm in federal court with Judge Mim, who could be an intimidating person sitting on the bench back in the day. I say that because I know Judge Mim, and he's one of the kindest and also a mentor, kindest people I know. So I don't mean that in any disrespectful way, but I was scared. What Max did, though, was he lined me up with other lawyers in town who had experience in ERISA cases. And he lined me up with a seminar, a 4-day intensive, 8 hours a day seminar in Chicago. Hotel room, the whole thing. Like a boot camp on this area of the law. And with another lawyer who was located in Chicago. And then for a minute, we employed somebody else with the client's permission who had experience in this area of the law. In other words, we fulfilled our absolute obligation to secure the assistance of a lawyer who is competent in the area of law or practice in which we are not. And what you see, and what I've seen over the next 35 years of practicing law, was that a lot of times lawyers fail to meet this expectation. For you, don't do it. But I noted that we engaged the lawyer from outside our firm, and that rule also requires that we must obtain the client's consent to do so, which we did. Rule 1.2 talks about the scope of representation, and the general rule is you always abide by the client's decisions and wishes. You can limit your scope of representation after consultation with the client, but you must obtain the client's consent to do so, and you better get that consent in writing. It's improper to participate in presenting or threaten criminal charges to obtain an advantage in a civil matter, and you have to be clear on that. Occasionally that comes up in family law. I think we discussed that as being something that people do in work comp occasionally as well, for those of you who had administrative law in the fall. As far as limiting your representation and what that means, sometimes people will come to you who have already been through another divorce and have a child custody or or more likely child support issue on another divorce. If they have ongoing other issues besides the matter that they're coming to see you on, make sure in your contract it notes that you're only going to do a certain thing. Whatever it is, you're going to represent them in this divorce, not anything else, and be very explicit about that. It's a good time to mention a contract in the scope of representation discussion. We'll talk about fees briefly, but my contract for divorces before I was able to thankfully start passing the divorce work in the firm off to now Chief Judge Gorman, had grown to about close to 7 full pages. It wasn't something that I created, it's something that I got from somebody else, but then I tailored it to our needs, and it spelled out every expectation to the best of our ability. And we were very careful because we wanted to make sure that the client understood what we would or would not do. We also wanted to be sure that they understood that if they were going to call and insist on talking to the lawyer as opposed to the legal assistant about their dissatisfaction about the other party taking the toaster, it was going to cost them a lot of money. We have minimums set. So if you call and rant to me for 2 minutes, 120 seconds about the toaster, it's going to cost you about 5 to 6 times what the toaster would cost if you just ran to the Walmart and bought a new one. We spelled all that out. All right, the next rule, 1.3, and it's always silly to me that we have to talk about this, but you have to be diligent. Be prompt in representing your client. So now you know a little bit of why I'm the way I am and why I expect the same of you. It's expectation of the law. It's kind of how I was wired. Do things on time. Hit the deadlines. Drives me nuts. Now, some lawyers, as I said, and especially in family law, will use the lack of diligence and get off with excuses or have excuses made for them by the court who allows things to be punted down the road. They use that lack of diligence to delay, maybe to churn fees, but to delay or frustrate or attempt to frustrate the other party, not caring how they again impact the dynamics of a family or the two parties trying to split a family and further the animosity or whatever it is between the parties and don't help the situation at all. There's an expectation that you're diligent. Rule 1.4 talks about communications, and communications is very important. It's something that I preach to you often. We have to keep the client reasonably informed and promptly reply to clients' requests for information. We have a duty to provide explanations that are sufficient for the client to provide authority to make decisions concerning his or her case. And I have a rule. It's a rule that I learned from the suggestion of other people back in the day when we didn't have email in the office and most clients didn't have email. And I would send the client copies of every piece of correspondence and every document that was generated by our office on the matter and everything that we received on behalf of the client. In a family law setting, this may be expanded to sending the clients copies of everything, all right? Everything. Now, it's easily done with email and PDF files. Much easier than when you had to stuff envelopes and lick stamps and the whole thing. What I will tell you about doing this, about following Higgins' rule on communication. In the more emotional cases, like family law cases or probate cases, the client may not always completely understand everything you're sending them, but they feel informed. And so they don't generate any sort of emotional phone calls or unnecessary communication or get dissatisfied. They feel like they know, they see that you are doing something on their case. And when they do contact you, they contact you with a substantive question, with a real need to know, with a more informed ability to communicate with you and have a better understanding. And they feel better served. And you know what? They're owed that. You should serve them in that way because you have to justify my next discussion, Rule 1.5 on fees. And that rule essentially says that fees should be reasonable, that the time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service is something that helps determine whether it's reasonable. Sometimes we consider the time that we have to take on a case and whether that will preclude us from other employment as to what the fee may be or whether it's reasonable. Typically, the customarily charged fee in that locality for similar services is what we look at. Occasionally, we look at the amount involved or the results obtained in a case. To be clear, and we'll talk about this down the road, but in family law, there are areas of the law, or most of the areas of the law in family law, you can't, for instance, say that you'll take a fee that's based on the amount of child support that you get for a client. You're billing by the hour. The time limitations, if I have to drop everything I'm doing to meet a deadline that you have for you in a case that you come to me with, then I might charge you more. The nature and length of the professional relationship, I might charge a client who is a long-term client or who may benefit me by referring a lot of other business a different rate or fee than I might charge somebody else. For instance, I used to represent the couple of the police unions locally, and I didn't charge them a whole bunch for most of the work for the union itself because I had a whole bunch of work referred to me through the membership. And then also, final factors, the experience, the reputation, the ability of the lawyer or lawyers performing the services. So the years of experience in that particular area of the field, their reputation, it may garner a higher fee or may determine what the fee they're able to get from a client would be. And then we always want to know if the fee is fixed or contingent. Again, contingent fee is that fee that I mentioned that you can ask for in child support cases, an example. Confidentiality. Without a client's prior consent, a lawyer may never reveal a client's confidence. This means not during or even after the representation has ceased, and including after the client's passed away. And what should be confidential? I say you just should consider everything confidential. But anything that identifies who the person is. Who does it have to be confidential from? Anybody who's not working on that case. That could include people from another area of your office within your same employer who are not working on that case. So you can't go to lunch and talk about the case to some of your friends who also work in legal services. Now you can in general terms, I'm working on this case, it's really a pain in the butt, and here's why. But you got to be sure that you're not giving away any identifying information. There are a few rules you noticed on conflicts of interest, and I'm going to sum those up in 4 scenarios. We can't represent a person we are suing currently or who is or may be adverse to the person or the position of another of our current clients. We can't represent any party against a former client without the former client's express, and when I say the word express consent, I mean written. Get it in writing. Now, most people aren't going to give you written consent to come and sue them, a former client, that is. I had that occur one time. I'm sure that it happens occasionally, but I went to court one time with a friend, had to go to traffic court. After we went to traffic court, he bought me lunch. That was my fee. Years later, he's running a huge corporation. A family friend gets injured working for that corporation, or working at that corporation, wasn't working for that corporation. Big personal injury case. They wanted me to be involved in it. The family did. And I went to my friend and asked if he might be willing to give me his written consent to be involved in the case against his company. And he said no. So it happens. And that was his right to say no. I got over it. And the party I was interested in being part of representation, they wanted me to be part of the representation. They got to a lawyer who didn't have a conflict and was able to continue on in the case. You can't represent a client if your own interests may be adverse to the client's. This comes up occasionally. A lot of times you have to be careful in the wills, trusts, and estates area because lawyers find things out about estate planning that relate to, in particular, property interest. And I remember a case where the mall is out on 150 at Route 6 in Peoria. I still call it the new mall. It's been there like 30 years. And I can't remember what the name of it is anymore. Shops at Grand Prairie. Anyway, that was a bunch of farmland. And a lawyer who worked on some of the estate planning for someone who owned some of the land ended up buying some of that property in that area. And it was a big thing. The family felt like they were duped. That he found out about development that was coming, and they thought that he should have shared that with them. And he did not, and he ended up, under the guise of just wanting to buy property, bought property from a client. That would fall in this category. The last one is if you change employment, you may not work on matters that are adverse to a former client or share a former client's confidences. The realities are that lawyers and paralegals switch firms all the time. I don't know how much this is held to, but if it's litigation, cases churn and close. So you don't hear a lot of cases coming out about violations of this. I'm not aware of a lot of IRPC or ARDC cases, but know that it exists if you change employment. Rule 1.5 says we have to keep our client's property safe. Primarily, that's the lawyer's trust account and keeping your client's money, their retainers, and any other funds separate from the law firm or the lawyer's accounts and funds. But remember also, and typically I don't recommend that you keep anything else that is property of a client other than that money, but keep in mind that the file is the client's property. The file is the client's property. electronically, paper, whatever. The file is the client's property. You're creating it, and we think of it as our file, but it's not our file. It's the work product that we create on behalf of the client. The client owns that file. It's their property. Bear with me just a few more. Declining or terminating representation. Declining versus terminating, you need to know the distinctions. Declining termination is when the person comes to us for the first time and we say, we don't want the case. Thanks, we don't want the case. There's certain things that we should do. And for instance, we need to let that person know that they need to seek the advice of another lawyer. We need to inform them of any statute of limitations or deadlines that we're aware of. And we need to document all that in writing as well as let them know very clearly verbally. Termination is different. That's when we've already taken the case. We've already decided to be involved. And if there's something filed in the court, we may have to have the court let us withdraw from the case. We have to ask the court's permission to withdraw from the case, which in most cases they do. If we haven't been to court yet, we just essentially the same letter that we sent on declining, and we change it to we're no longer able to represent you in this case, and we do all those same things. Regardless of the scenario, the file should be well documented, client well informed of his or her rights, the time limits, etc., and additionally advised to seek the advice of another lawyer ASAP. Rule 3.1, I'm jumping to, covers meritorious claims, and any claim or contention has to be supported by existing authority or a good faith argument for the extension of existing authority. 3.2, think back to our diligence rule, covers expediting litigation. Family law cases are litigation. Probate matters are litigation. Don't drag your feet. See diligence, Rule 1.3. We actually have a rule. Fairness. Again, another one where I'm like, just really? We have a rule on fairness. We have a rule that dictates that we be fair. And in family law cases, this reminder may be needed for litigants and some lawyers. In a nutshell, the rule urges lawyers to refrain from hiding the ball, creating unnecessary delays, and generally avoiding bad behavior. To essentially playing fair and be respectful if they can't be nice. All the things your parents taught you or should have taught you before you're 5 years old is what I like to say. And again, I've experienced this firsthand with family law lawyers. Recently, in the near term. It shouldn't happen, but it does. And especially when I want to emphasize in family law or probate matters for that case, you're dealing with people's emotions, with their relationships, with the need to probably have some sort of relationship going forward or their peace to be able to go forward. They're going to be connected and you won't be. So if you don't play fair and be respectful and you don't do things fair and according to the rule, or you bend the rules or try to skirt the rules, and if the court allows you to, you not only violated this rule, but you've impacted unnecessarily the lives of somebody else. I'm going to talk about rules regarding dealing with non-clients. So non-clients would be other people. If somebody's represented by a lawyer, or we never talk to anybody represented by a lawyer, and typically that's going to be the other party, okay? But sometimes there are other people. They work for a corporation that's involved in the case. You need information from that corporation. They tell you they're represented by a lawyer. Stop the communication. Other than find out who the lawyer is and then move the communication to that lawyer. Anytime anybody's represented by a lawyer, you talk with that lawyer. Written authorization is required if that lawyer tells you you can talk to that other party or the other person if they're not a party. With unrepresented people, always make sure they know your position, who you represent, and what your motives are. All right? That's the person who could be a party or may be a party but doesn't have a lawyer. A lot of times in family law cases, we see where the other party does not have a lawyer. They're going up unrepresented for whatever reason. And then the rights of third parties. Essentially important in any litigation, as you learned in civil litigation. These folks have nothing to gain except for inconvenience, and treating them with recognition of this inconvenience has more potential benefits than not doing so. It can impact your case positively or negatively. If they don't have anything to offer, or even if they have something to offer that is detrimental to your position or your case, so be it. But treat them with respect. Good people who you tick off will do you. They will either withhold the truth or be untruthful, or at the very least, be uncooperative. So treat them how you'd like to be treated. Just golden rule those third people. Do it with everybody, but third persons especially. The people have nothing to gain from this case except being inconvenienced. And some of you have probably been asked to be a witness in something at some point, and you know that's true. Final rule before I talk about malpractice and we shut this off. Rule 5.3 says the lawyer must train, support, and take responsibility for the actions of subordinate lawyers, paralegals, and other support staff. One of the things I like to advocate for here and tell you to advocate for in your own careers is continuing legal education. If you end up going to law school and becoming a lawyer, that's going to be required of you. 30 hours currently every 2 years in Illinois. You're going to have to do it. Some lawyers are better about providing or seeing the importance of continuing legal education for their support staff, their legal assistants, their paralegals. All lawyers should be. So advocate for yourself if you're in those positions and you don't have a mandatory requirement for continuing legal education. I just want to talk about malpractice. Malpractice is negligence by a professional. A lawyer or staff person who follows the IRPC is less likely to slip up than the lawyer who ignores or attempts to get around the IRPC, and risking both your malpractice coverage or, more importantly, law license. Just don't do it. Know what the code expects and follow it. Some other family law and, to a degree, wills, trusts, and states specific professional conduct points and things that relate to that topic of malpractice. Emotion. These clients can be emotional, as I've said. See past the emotions and don't let yourself become emotional or get drug into the emotions, either on their behalf or when they challenge or tick you off, which will happen. Communication. Know your expectations. Know the expectations of the client, the lawyer, document the file, cover your butt, Higgins rule, all the stuff. Calendars. Have a checklist. Do file reviews. Review court dates. Update and review those daily. And then make sure you sit down with the lawyer and review the case on a regular basis. I think you may remember, if you had civil litigation, that our practice was Dean Weghorst, when she was working with me on litigation cases, would line up a time for us to meet every week. And that always varied on the day and time because I was all over the state and courthouses. But she would line up a time so that we would review every single case every 30 days at least. And if something was coming up for trial, we might review it more often than that, maybe daily in some way, shape, or form. I'll offer some mays and may nots in the um, in my post later in this week some things that you can keep in mind, and I would copy those and put those um, somewhere that you could because they provide a nice little summary. But I wanted to say, just in closing, the unauthorized practice of law is something that always concerns me, and that means that if you aren't a lawyer, you can't provide legal services or legal advice directly to someone. And probably in family law more than any other area of the law, in my time as a lawyer, I have experienced where lawyers allow their support staff, their non-lawyers, to do this. Know this: they are setting you up for a charge of unauthorized practice of law. They are doing something that they will eventually not pay attention to and get in trouble over. Or you'll do something and they'll throw you under the bus. It is a crime. If you want to give legal advice or provide legal services directly to anyone, get admitted to law school, complete law school, pass the bar exam. Okay? Until you do, don't provide any of this information, services, documents, advice to anybody. Not to your best friend, your worst enemy, your grandma, your mother, your child, or anyone. Or you could face prosecution. And I could be the person who turns you in or testifies that you knew better. So just don't do it. Okay? Don't do it. And it happens. Sometimes it's hard because your boss, the supervising lawyer, tells you to do it and you think it's okay because they told you to do it, or you feel coerced to do it because they pay you. Just say no, because it always ends badly at some point. I'm just going to get off here and say, if you need me, you know where to find me. Week 1, onward, family law.